Today we are going to discuss a very important topic in law of contract. That is test of legal validity of contracts, part 1, because it's one of the largest topic to be covered in law of contract because the foundation of principles of law of contract is all about testing its legal validity. So there is one statement: all contracts are agreements, but all agreements are not contracts. That signify, as Section 2H of Indian Contract Act says, an agreement enforceable by law is contract. In this lecture, we will try to understand which agreements are contract, what test of its validity is, and which agreement can be enforced by law. So our focus would remain on essential prerequisites of free consent, contractual capacity, lawful consideration, object as stipulated by Indian Contract Act 1872. So first of all, the first thing is free consent. Consent must be genuine and uninfluenced by external pressures. We would be discussing it in detail. Competent parties, individuals must possess that legal capacity to enter into agreement who are not competent. Again, we would be discussing. Lawful consideration and lawful object. The purpose exchange must be legal, not against the public policy. The fourth important component of a test of legal validity of a contract is any agreement which should not be expressly declared void by any law. So, Section 10 of Indian Contract Act, for an agreement to become a valid contract, it must satisfy several crucial conditions. These include obtaining free consent from all the parties who are the part of agreement, ensuring that all parties are competent to contract, establishing a lawful consideration and lawful object. Furthermore, an agreement must not be one that is expressly declared void by any statute law. Thus, capacity, consent, and consideration form an indispensable pillar upon which the legal validity of any contract rests. Now, coming to the capacity of the party, a person should be major and he should be or she should be a person of sound mind and he should not be disqualified by law. So, individual must have reached the age of majority. Generally, it is 18 to enter into a binding agreement. Contracting parties must possess the mental faculty to comprehend the terms and implications of the contract. Sound mind means the person has the ability to understand what he is agreeing upon when it comes to uh, entering into an agreement. Certain legal statute may impose restrictions on specific individuals from contracting, regardless of their age and mental capacity. Section 11 of Indian Contract Act meticulously defines who is competent to contract. It mandates that every person is competent to contract who is of the age of majority, is of sound mind, not disqualified from contracting by law. So this provision serves as critical safeguard, ensuring that only individuals who are legally capable and aware of their actions can enter into enforceable contractual obligations. It protects vulnerable parties from exploitation and maintains the integrity of contractual relationship. Now coming minority. Minority is a disqualification of a person is not considered as competent party or doesn't have capacity to enter into a valid agreement. A contract with a minor is void ab initio, meaning it holds no legal force or effect whatsoever. No ratification. Ratification means a minor cannot legally confirm or approve a contract upon reaching the age of majority, as initial agreement was void. So upon the attaining of the age of majority, there can't be any correction. One more thing is important to understand and to keep in mind is here, despite journal voidability, a minor can enforce a contract specifically made for their benefit, upholding equitable principle. Meaning thereby, if there is any term where minor can be benefited through that agreement, minor can enforce that benefit provision of that agreement. He cannot be held liable rather. So as per Indian Majority Act 1875, a person below 18 years of age or 21 in case involving court appointed guardians is legally considered a minor. So legal effect of a contract with a minor is profound. Such a contract is void ab initio or invalid from the very beginning. This means it cannot be ratified by minor upon attaining majority. However, a minor can indeed enforce a contract made for their benefit, as demonstrated in a landmark case of Mohri Bibi versus Dharmodas, where Privy Council unequivocally held that a contract with a minor is absolutely void with no room for estoppel against the minor. Persons of sound mind, section 12, understand the contract. The individual must be capable of comprehending the nature in terms of agreement, meaning thereby a person has ability to understand the nature and consequences of that agreement. That is called being a person of sound mind. Judge its effect. They must be able to assess how the contract impacts their personal interest and obligations. So, Section 12 of Indian Contract Act, a person is deemed to be of sound mind for purpose of contracting if at the time of making the contract they are capable of understanding the contract, judging its effect on their interest, and this encompasses a wide range of mental incapacities, including idiocy, lunacy, temporary state of drunkenness, intoxication that impair rational judgment. So, onus of proving the unsoundness of mind at the time of execution often lies with the party asserting it. As I underscored in Indra Singh versus Parmeshwadari Singh, where contract by a person proven to be insane at the time of execution was declared void. So this provision aims to protect individuals who lack cognitive ability to make informed decisions, preventing potential exploitation. Disqualified persons deemed incapacity, insolvent, legally prohibited from transferring certain properties as their assets are under court administration for debt repayment. Alien enemies, citizens of country at war with India whose contractual relations are suspended, restricted during hostilities, they are disqualified. Corporations, their contractual capacity is limited by their memorandum of association and constitutional documents defining their scope of business. Convicts temporarily lose their contractual capacity during the period of incarceration and regarding its upon release. Beyond minority and unsoundness of mind, certain individuals are disqualified from contracting by specific law, resulting in deemed incapacity. These include insolvents who cannot transfer property once declared bankrupt, alien, foreign sovereigns, diplomats, convicts, corporations. Now coming to the chapter of free consent. Free consent is covered under section 13 and 14. Free consent has been defined under section 13. Uninfluenced and genuine consent free from coercion, undue influence, fraud, misrepresentation, and mistake. So meeting of minds, parties agreeing on the same thing in the same sense, forming a fundamental agreement. There is one maxim, consensus ad idem, when two or more persons agree upon the same thing in the same sense. So section 13 of Indian Contract Act defines consent as existing when two or more persons are said to consent when they agree upon the same thing in the same sense. So this concept, often referred to as consensus ad idem, is fundamental to contract formation, ensuring that parties are truly on the same page regarding the terms. Building upon this, Section 14 elaborates on free consent, stipulating that consent is not free when it is obtained by factors like coercion, undue influence, fraud, misrepresentation, or mistake. The absence of free consent renders a contract voidable at the option of the party whose consent was not freely obtained, underscoring the importance of genuine and unforced agreement in contractual relationships. Now, coming to vitiating factors affecting consent. Coercion is defined under Section 15, consent obtained by actual or threatened illegal act or unlawful detention of property. Coercion means creating the fear in the mind of a person in order to obtain the consent. So, legal precedent, landmark judgment, Chikham Ammi Raju versus Chikham Shishamma established that even threat to commit suicide constitute coercion. Effect on the contract. So a contract formed under coercion is voidable, allowing the coerced party to resign at their discretion. So coercion as defined under Section 15 of Indian Contract Act involves compelling a person into contract through forbidden acts or unlawful detention of property. It encompasses any act forbidden by Indian Penal Code. Now it is Bharatiya Nyaya Sanhita, even if not directly involving physical violence, illegal retention of someone's asset to force their agreement. A significant legal precedent for coercion is Chikham Ami Raju versus Chikham Sishama, where threat to commit suicide was held to amount to coercion, rendering the agreement voidable. When consent is obtained through coercion, contract becomes voidable at the option of the party whose consent was so caused, allowing them to choose whether to uphold or cancel the agreement. Now coming to undue influence. Undue influence means when parties to the contract are under fiduciary relationship. Now, question is, what is fiduciary relationship? That is very important aspect of contractual relationship. Fiduciary relationships are those relationships where one party is in position to dominate the will of other. For example, parent and child is a fiduciary relationship where parent can easily dominate the will of the child. So natural authority of a parent over child may lead to presumed undue influence in contractual matters. A doctor and patient is also a fiduciary relationship. A doctor's position of trust and medical knowledge can create dominant influence over patient decisions. Guardian and ward. Guardian holds significant sway over ward's affair, making transactions between them susceptible to scrutiny. So, undue influence, as outlined under Section 16 of Indian Contract Act, occurs when one party is positioned to dominate the will of another due to a special relationship, using the dominance to gain unfair advantage in the contract. So, this dominance is often presumed in certain relationships, such as between parent and child, doctor and patient, guardian and ward, where trust and dependency are inherent. In such cases, the burden of proving the contract was not induced by undue influence shifts to the dominant party. Principle is vividly illustrated in Rani Annapurna versus Swaminathan, where a contract in which an illiterate widow was induced to gift her property was held voidable due to presumed undue influence. This provision safeguards vulnerable individuals from exploitation by those in position of power or trust. Now coming to fraud. What is fraud? That has been defined under Section 17 of Indian Contract Act. False assertion, making a statement known to be untrue. Active concealment, where deliberate attempt has been made to hide the facts. Promise without intent, making a commitment with no intention of fulfilling it. So fraud is defined under Section 17, involves intentional deception, aimed at inducing other party to enter into contract. This multifacets concept includes several acts, suggestion as a fact of which is not true by one who does not believe it to be true, active concealment of fact by one having knowledge or belief of the fact, and promise made without intention. The essence of the fraud lies in the dishonest intention to mislead. The seminal English case of Derry versus Peake, that is a landmark judgment, provided in a classic definition of fraud as intentional deceit, setting a precedent for understanding element of fraudulent intent. A contract procured through fraud is voidable at the option of the defrauded party, allowing them to recourse to the invalidate the agreement. Misrepresentation is defined under Section 18, innocent but false statement inducing other party, voidable if misled party would not have contracted otherwise. Mistake is covered under Section 20 to 22, common mistake, Section 20, both parties mistaken about the fact is void. Galloway versus Galloway, agreement to separate when no marriage, void. Unilateral mistake usually not void unless about the nature of contract or identity of a party. Now coming to consideration. Consideration is defined under Section 2D, and according to Section 25, an agreement without consideration is void. So consideration is when at the desire of the promiser, promisee, or any other person does something, such act is called consideration. An agreement without consideration, according to Section 25, is void. So essential elements of consideration are must move at promiser desire, may move from promisee or third party, must be real and lawful, need not to be adequate. Agreement without consideration are void except out of natural love and affection, past voluntary services, promise to pay time-barred debt. The case is Chennaiya versus Ramaya. Consideration can move from third party also. Now, to conclude this lecture, a contract must be formed by the party legally capable of contracting with genuine free consent supported by lawful consideration. Factors like minority, insanity, coercion, fraud, misrepresentation, mistake impair the contract's legal validity. Courts ensure these fundamental principles are upheld to maintain fairness, autonomy, and trust in contractual relationship. With this, I would end here. Happy learning.